Hello. Expression of European Convention on Human Rights, Article 10. Now, what does freedom of expression mean? Well, the European Declaration on Human Rights came into force in 1953. If you look on the map on the slide I've got at the moment, you can see where I'm moving the slide button. All that's in green are all the countries that have signed the European Declaration on Human Rights. So it's more than the EU. It extends far beyond them. It's the Council of Europe, which is a different organisation entirely. So what does Article 10 of the Convention say? Well, it says everyone has the right to freedom of expression. And expression means more than simply speech or writing. It extends to a lot of different things. This right shall include freedom to hold your own opinions and receive and impart information, ideas without interference by the public, authorities, and regardless of frontiers. So we're talking about a quite extensive right to be able to say what you want to say, hold opinions, receive and give out information without interference. But are there any controls? Well, Article 10.2 states the controls. It says that you can be, the state can set formalities, conditions, restrictions or penalties which are necessary in a democratic society. And then they give examples such as national security, public safety, prevention of disorder or crime, for the protection of health or morals, as we've known for the protection of health at the moment with the COVID issues. A lot of restrictions have been placed on individuals throughout Europe and in this country as well. And your ability to say things has generally not been restricted, but some false information or misinformation has been restricted in relation to websites and things like that, which shows that's perfectly lawful. It also talks about the protection of reputation. That's slander and defamation, that you can't slander someone or defame someone without telling the truth, for example. So what do we mean by freedom of expression? Well, sign language is a form of expression, speech, the written word, photography and film, paint or drawing, and also we have making plays, parodying, that sort of thing. We can come up with some examples of issues about freedom of expression. Cartoons, political cartoons. I've chosen to show one here that relates simply to British political cartoons. But in France, there's a political cartoon where they made depictions of the Prophet Muhammad, and that caused extreme offence to Muslim population, and they were attacked by terrorists because of it. So freedom of expression would say they had the right to do what they did. But you could argue that that right should have been restricted because it offended a whole religion. Let's talk about other examples where you have, for example, I've used the film Citizen Kane, which was about Hearst, who was a newspaper publisher in America, and his power, and it was a critique, but it was done in his name. It was done as a work of fiction. Then you have someone's powerful words. I have a dream. The I have a dream speech was Martin Luther King speaking from his heart, and that speech is an example of freedom of expression. Another example would be the film Life of Brian, which on one level is a comedy and satire. At another level, it effectively insulted a lot of Christians who strongly believed that it was offensive to them. And then we have freedom of expression in China when a photograph was taken of a man trying to stop tanks with his shopping. Sign language, as I've said before, written words such as Lady Chatterley's lover, which was banned because of obscenity laws at that time, and then the ban was lifted. And vlogs are another example of freedom of expression. What I'm doing now is an example of freedom of expression. Next slide. Historical reasons why the law has intervened. Well, in this country, we've never allowed a right to unlimited free speech at any point, because words, expression can have consequences. Shouting words like fire in a crowded theatre. If you had total freedom of expression, you could do it, but the consequences of shouting fire and alarming people in a theatre are colossal. People may panic and trample each other, and people may actually die just because someone shouted fire. Also, freedom of expression includes plots, schemes, conspiracies, people conspiring together to commit crimes. And as we've known, if we go back on the previous slide, just bear with me a sec. If we look at the previous slide, it shows that there are restrictions allowed under Article 10.2 for the prevention of disorder or crime. So, for historical reasons, the law has intervened, and English law has never allowed a right to unlimited freedom of expression. And as I've explained, shouting words like fire in a crowded theatre can cause panic, and it's never been permitted because words can incite others to cause harm. Planning or plotting to commit a crime with others is a conspiracy to do something. For example, in history, let's remember the gunpowder plot. Remember the 5th of November for gunpowder treason and plot. why the gunpowder treason should ever be forgot. Well, blowing up Parliament and the King, which was what the plot was, James I of England and James VI of Scotland, the same person. The plot was to put the gunpowder in the cellars of the Parliament and blow those people up so that it would launch a Catholic revolution, and the Catholics would then take over from the Protestants in running the country. That was the plot in a nutshell. And the plot, or part of the plot, was the conspiracy, the conversations, the meeting together, the planning. All that is expressions, but it was incitement and conspiracy, and it was treason. And it would be terrorism today. So what are the elements of a conspiracy? Well, helpfully, the law says in Mulcahy and the Queen, 1868, so a while ago, that conspiracy is an agreement where two or more people agree to carry their criminal scheme into effect. And the very agreement is a criminal act in itself. So once they've thought about a plan and they've come up with a plan to commit a crime, for example, let's go shoplifting together tomorrow and let's steal a lot of perfume from George Henry Lee's. That's a conspiracy. Once my friend says, oh, I agree, we'll meet under Lewis's statue in Liverpool on Lime Street. And they agree a time and date, and then they intend to carry out these thefts of the perfume. That would be a conspiracy to commit theft from shop. On the same basis, the conspiracy in itself doesn't have to take place for the crime to be made out. It can be stopped. Now, the case of R.V. Aspinall, 1876, says that repentance or lack of opportunity or a failure are immaterial. So if something intervenes to stop the plot, for example, in the one I've given where we're plotting or conspiring to go shoplifting, if my friend gets off the bus, slips and breaks his leg so he can't go shoplifting with me, that wouldn't mean there wasn't a conspiracy. The conspiracy crime has already been made out. What is critical is that it's a course of conduct which has been agreed between more than one person and another. So it needs two people to have that plot. The fact that you don't perform the plot or commit the substantive offence does not absolve the parties from liability for the conspiracy. And that's R.V. Bolton, 1994. And I gave you a link on the bottom of that. Conspiracy is a part of, and this is a big technical legal word, innocuous offences such as aid, abet, counsel, procure, or commit a conspiracy or an attempt. They are all what is referred to as innocuous offences, and they are offences other than the substantive offence, but there are offences nevertheless. So you can be guilty of aiding and abetting a crime, assisting an offender after a crime, etc. Inciting or encouraging someone else to commit a criminal offence by another, well, we're looking at a case in the United States, so it's not law in this country, but it mirrors the law that already exists. As you can see on this slide, I've referred in part 2 to the Serious Crime Act 2007, sections 44 and 46, and they refer to the innocuous offences that I referred to earlier of assisting an offender, encouraging or assisting an offence believing it will be committed, or encouraging or assisting offences believing one or more will be committed. And the quote refers to Wendell Holmes, who was a very famous judge, who wrote that no free speech safeguard would cover someone falsely shouting fire in a theatre and causing a panic. Freedom of expression and public order. On the one hand, we should be free to say what we want. But on the other hand, if what we say harms another or puts someone in fear of being harmed or insulted, then should that be restricted? Well, the Public Order Act 1986, Section 4, which is the one relating to threatening behaviour, a person is guilty of an offence if he uses towards another person threatening, abusive and insulting words or behaviour, or distributes or displays to another person in any writing, sign or other visible representation which is threatening, abusive or insulting. But there is more than just having to do that. So there has to be an intent. Legal posh word for intent is mens rea, which is Latin, to cause that person to believe that immediate unlawful violence will be used against him or another by any person, or to provoke the immediate use of unlawful violence by that person or another, whereby that person is likely to believe that such violence will be used or is likely that such violence will be provoked. So what does that mean? Well, in a nutshell, it means that what you say may have consequences. If you threaten someone, I'm going to kick your teeth in, that's a threat. And you make that threat and the person believes that this is going to happen within a very short time frame, or believes that your friend is going to carry out that assault for you, then you would be guilty of an offence of threatening behaviour. But it doesn't mean that just simply being abusive or having insulting words which hasn't or is not linked to threats of violence is an offence under Section 4. It's not. What frequently happens is that the police tend to read Part 1A and they forget they need B as well. You have to use threatening, abusive, insulting words or behaviour which has an intent to cause the person you're using that behaviour towards to believe that they're going to be subject to an assault, an immediate unlawful violence. So if the violence element is missing and it's simply an insult, then Section 4 is not made out. This is why the police frequently get it wrong. Let's look at it in some detail. Why would this be a potential example of threatening behaviour? Aggression and anger in body language, invading someone's personal space, making threatening gestures, the raising of the fist, the reaction of the victim showing that they're in fear of personal violence because she or he is covering her face and clearly expects to be hit. If you look at the picture on the background, the man is clearly angry. His hands are balled up into a fist. The woman is covering her face and head and is clearly in fear that she's going to be hit. Section 5. Remember, we just discussed Section 4 of the Public Order Act 1986. Now, Section 5 is a lesser offence. Harassment, alarm or distress. The offence, Section 5(1)(a), a person is guilty of an offence if he, and that means she's as well, uses threatening or abusive words or behaviour or disorderly conduct, or displays any writing, sign or other visible representation which is threatening or abusive within the hearing or sight of a person likely to be caused harassment, alarm or distress. So you've got to use threatening or abusing words or behaviour or disorderly conduct, and it's got to be within the hearing or sight of a person likely to be caused harassment, alarm or distress. Heads up, police are not likely to be caused harassment, alarm or distress by someone using abusive language or behaviour. It needs more than police officers. It means members of the public going about their daily activities. And if you're vlogging and there's no one around except a police officer, how can they be caused harassment, alarm or distress if you swear at them? But many police officers will warn and then arrest, presuming or inventing members of the public who are caused harassment, alarm or distress who are simply not there. Well, if that's happened to you, you need to be able to prove that there weren't members of the public around. And how you would do that is you would go about making applications for access to CCTV, things like that, or body cam footage. Historically, and when we're talking about free speech and expression, it's important to remember the historical context of it. The medieval law of treason and the use of torture to force confessions was common practice. For example, Sir Thomas More was convicted of treason during Henry VIII's period because he would not accept that Henry VIII was the head of the church. At his trial, they could not show that he thought what he thought was treasonous because he exercised silence. What they did convict him of was treason because he refused to take the oath, and that's what led to his execution. That's Sir Thomas More. Other examples in the past: heresy and blasphemy. Heresy and blasphemy suppressed religious freedom and free speech in the medieval period and afterwards. Heresy covered any belief that did not match what they call a catechism in the Church of England. Well, that concludes our first trip into the human rights law, and we've looked at freedom of expression and some of the historical background to freedom of expression and freedom of speech. And hopefully you've realized that freedom of expression isn't absolute. There are some crimes or offences that you can commit with freedom of expression. We will talk in more detail later about freedom of expression and terrorism and rules under the Terrorism Act specifically at a later date, because it is a subject on its own that is quite complex. But I thought it would be helpful for you to have an overview of freedom of expression and the basics at the beginning of the course. My name's Anthony Hughes. I've got a PGCE. I've got a master's degree in law, and I'm a non-practicing barrister. Hope you enjoyed this. Please subscribe, and this is all totally free. Thank you. Subscribe. As I say, my name's Anthony Hughes, and everything, of course, is totally free. I'll speak to you soon on our next video blog, or as young people call it, vlogs.